Let's move to this now. My colleague Thulasizwe Simelane is also in Pietermaritzburg. This ahead of the proceedings today with regards to former President Jacob Zuma's appearance. Now, Thulas, good morning to you. Let's talk about that warrant of arrest which was issued a bit earlier on for the president. I decided it was sometime in February. Will it still be proceeding?
Absolutely. In terms of the Criminal Procedure Act, experts say that it is almost routine that if an accused is expected in court and doesn't present themselves in court on a particular day, an arrest warrant is then issued. In fact, former President Jacob Zuma's legal team were downplaying the significance of it all. I remember at the time when it was being reported that the court had issued an arrest warrant, saying that it's pretty routine, with the condition that upon the return date, the next sitting of the case, then there will be what is called an inquiry into the circumstances that led to the accused person not being in court at the previous session. And that inquiry, one expert tells me, will then require former President Jacob Zuma to fully explain the medical treatment he was seeking and perhaps even give evidence. And that's a matter that's sort of in dispute between the prosecution and the defense in terms of, whether adequate evidence has been given of the medical assistance he was seeking in Cuba. That's one of the many issues, though, Dumi, that will come up inside the court behind me. Other issues have to do with the defense's unhappiness around the position of the judge president continuing to play a role in the pre-trial processes. They're basically unhappy about communication between the lead prosecutor, Billy Downer, and the judge president of the province of KwaZulu-Natal, and basically are raising issues around that. They're calling it ex parte communication, that it is communication between one of the parties, not all of the parties, just one, and the judge president, and that makes them unhappy. There are issues around the indictment, the prosecution seeking to make amendments to the indictment. So what does it all mean then for the pre-trial phase of this particular case? I put that question to one attorney, that is Mpumelelo Zigalala, and I began by asking him whether this is significant at all, given that we are not really at the start of the trial itself, but it's a pre-trial.
The judge president, as the person who presides over the division, is the one who determines which judges are going to hear the matter, and also is the one who's going to determine whether the matter is ripe for hearing, and actually allocates data according to the role and dates that are available on his side. So it is important that he is kept abreast of the developments. However, practice has been that when communication is done, you communicate with both parties to ensure that the transparency, and also to ensure and eliminate any instances or maybe allegations of biasness that may be alleged at a later stage by either of the parties. So his role is to make sure that the matter is enrolled on time, the matter is being heard on time, that all the logistics that are required from the judge's side or from the court side are well attended to within the recommended amount of time. And when the judge or the court is ready, they are ready to get the ball rolling without any time being wasted.
Is it unusual to have one of the parties objecting to the judge president taking part in that process, particularly then link that issue to the issue of that selection of the judge or judges to preside over the actual trial, not the pre-trial? Can whatever suspicions of, undue behavior on the part of the judge president affect how the judge was eventually chosen to conducts the trial?
No, you see, if you would want to state an allegation of that sort, you would have to come up with substantial evidence and show how your client is going to be prejudiced by the judge being allocated, or the type of judge that has been allocated, or the person that has been nominated to listen to your case. If there's no substantial evidence to that instance, that it remains just an allegation. But also you must remember, there's an opportunity within the trial stage of saying that I've been allocated a judge, I'm not happy with the judge because there might be elements of biasness that I have seen and I have record of evidence of. Please change the judge so to ensure that justice is not only being served on paper, it is actually being seen to being served. So whether a judge is allocated or chosen now or at a later stage, it really doesn't make any difference if there is no evidence that will support that the allegations of biasness at a later stage.
So lastly then, let me ask you about this issue of the of making what the prosecution is calling minor amendments to the indictment, particularly the schedule, which, from which we have this whole issue of 783 instances and transactions that are part of that schedule. They want to amend that and add more payments and have a new role for some new auditors. Can that be done in the pre-trial phase?
It can be done. You must remember that the amendment of the charges is only not allowed up until the accused actually pleads. So if the accused hasn't pleaded, whether they are guilty or not guilty formally, the charges can be amended as and how the prosecution sees fit. There may be an objection from the side of the defense where they will say, we have sat for a number of months preparing for your case within these sets of charges. Now you are coming at a later stage and you want the trial to proceed, and you are saying that you are going to change the charges at a later stage. So we are not going to be prepared to deal with the matter at the set down date. Give us more time for us to prepare. However, in this instance, taking from what has been said within the meeting, the defense team seems to be saying we are ready at all costs. We are just waiting for a day in court so that we'll be able to deal with the matters and for all. So whether you want to add more charges or you want to remove other charges, let's set down a date within this year so that at the end of the day we'll be able to put this matter to bed. Another thing that you must remember, before the accused has pleaded, the charges can be removed so that you withdraw those charges and then you lay them again at a later stage. However, once the accused has pleaded, you can't bring new charges again. You can't bring the same charges again. So it's important that when you say you are ready, you want to say, in this case, the former president, Jacob Zuma, you must make sure that you have done your homework comprehensively. You must make sure that your evidence is such that when it is being tested in court, it's going to meet the beyond reasonable doubt principle, so that at the end of the day, you are able to get a conviction. Otherwise, all you are going to end up with is a high number of counts and a high number of charges that you can't prove beyond reasonable doubt, and the court will be left with no option than to say that the person who's being accused is not guilty due to the level or the quality of the evidence that you've brought in is not enough to guarantee a conviction.
And so, Dumelo, as I hand back to you, a quick mention that we've just gotten confirmation from former President Jacob Zuma's spokesperson, Vukile Matabela, that he is definitely coming through to be here in court this morning. This wasn't always a given because the prosecution had conceded that he doesn't have to be here as this is the pre-trial sort of phase. He didn't need to be here, saying that he's part of the vulnerable group in as far as the coronavirus is concerned. But we've got confirmation he will be here, and so is his son Edward Zuma, also inside court.